May it please the court. My name is John Phillips. I represent Aaron Joynt. I was also trial counsel, should you have any questions directed towards that. The way counsel ended is the way I want to start. The remediator was withdrawn. This is an all or nothing standard based upon whether this should have ever gotten to the what should have gotten to the jury, and whether the feather's weight we have left.
What evidence was presented other than the $80 for medicine that the jury could reasonably calculate the amounts that they came to with the $500,000 amount or the $100,000?
Yes, Your Honor. Dr. Triggs, in the record 2506, Dr. Triggs was Volusia County's own expert. Ms. Joynt didn't exactly want to go to the doctor. She didn't want the surgeries. She learned a lot about her condition and a lot about her severe damages from Volusia County's own experts. And at the record of 2506, Dr. Triggs referenced antidepressant medications to a reasonable degree of medical probability or certainty, and I'm getting to your point. Record 2529 to 2533, Dr. Triggs discusses in great detail continued doctor's visits with generalists and specialists.
Any cost though? Was the jury ever given how much is it going to cost to go to these doctors?
The jury had Miss Joynt's bills.
Was there a delineation in the bills, and I'll have to go through because it was very difficult. Was there any delineation that this is for a doctor visit, this is for this amount, so that the jury could make that determination other than a general bill? Certainly,
they could determine what the general price of a generalist bill was, Dr. Norris, or the specialist bills, Amstutz and Kreiser. And going as to further x-rays related to the thoracic and thorax pain, Dr. Triggs said she'd need that. There were other prior experts, x-rays they could compare to. And I asked, after 4 pages of discussion of these future issues, doctor, is that to a reasonable degree of medical probability or certainty? And he said yes. And again, that's record 2532 and 2506. So, to the extent that it's saying that we didn't prove anything to a reasonable degree of medical probability or certainty, I think it did. I think Ms. Joynt and Volusia County, even at the directed verdict motion, conceded to this. Mr. Carroll said Ms. Joynt probably took care of that herself. They proved that, record 2776. So certainly, Your Honors, we did, as trial counsel, as the one that bears the albatross around my neck for the reason we're here, I didn't use the magic words every time. The hearing aid, I probably blew it. But that's not the standard. We're not here on remediator today. We're here on, did we prove anything? And Dr. Triggs alone gave us damages to a reasonable degree of medical probability or certainty. On that issue, Dr. Triggs stated that 2014 offers Ms. Joynt no cure, no neurological cure. And what the Volusia County wants to do is say it offers her no treatment. So moving on to future medical capacity, I revisited my closing in preparation for today, and the question I asked the jury is she still perfect for that job, the job that she has, teaching speech to children? And the significant whole thing...
Talking about the lost wages?
Sorry, I moved on to earning capacity,
okay,
yes.
Okay.
If there are any further questions about medical bills? Okay. And, even over here, we were kind of going through the difference between a P and a B, or a D and a B. And the tongue tip elevation, the plosive sounds, the ability to say pop, pop, popcorn.
I get that. But there was no testimony regarding, and she testified she was perfectly happy doing the job that she was doing. She increased her salary from the time that because she was voluntarily unemployed at that time, to go home and do the noble job of being a stay-at-home mom, which is the hardest job in the world. But then she goes back and she's earning more. And I didn't see anything in the record that indicated what she would have made, what salary she would have made had she been able to pursue her dream of being a teacher. And without some sort of record evidence of anything that she would have made, I have a difficult time of seeing how the jury can come to the figure that they did.
And I would understand if the question is whether we're worried about, or the concern with the jury, or analyzing, armchair quarterbacking the jury as to whether Ms. Joynt would have had increases, or the difference between the paraeducator and a full-time teacher. If that's the issue, I would agree with you, and that's where I said to the jury, this may be zero. I said it 2 or 3 times, this may be zero.
Well, we know it was zero when she was injured. It was a goose egg. I mean, believe me, I believe what she was doing was a valuable. Raising her children was obviously, can't put a price tag on that, but it went from 0 to 18, and then there was nothing for the jury to measure beyond the $18,000 a year.
Unless you take the $18,000 a year away, which is exactly what they did. They took this basically minimum wage formula and said, you know what, you're a threat. You're a threat to these children.
But that's her possibilities. There was no proof that she was a threat to these children. Quite the contrary. There was proof that, and I commend her because, and let me just say that, because from reading her testimony, she didn't get on the stand and try to embellish anything. She's probably plaintiff's lawyer's worst nightmare in that she's saying, I don't want to have these surgeries. I'm happy in the job that I have. I'm doing well in my job. I have found a way to accommodate, where I move the chairs. I mean, she's done everything to do the job which she loves to do. And the testimony from the principal was that she's an excellent employee. Her evaluations are good. In fact, kids have progressed so well in her classes that they no longer have to have this remedial reading. And so there's nothing in the record to indicate, except some speculation that maybe one day, but something can happen to anybody any day, that one day maybe we might have to reevaluate if she all of a sudden doesn't perform. But that's just mere speculation.
And I respectfully disagree, Judge Berger. What Dr. Beck did and what the jury saw with her testing is so very significant. And Dr. Trigg saying, if you believe her memory tests, and you just described a very candid woman, if you believe her memory tests that I gave her, this is a woman with early onset Alzheimer's in some aspects. And so we have a woman with a brain injury to the point, one of defense zone experts is saying she's similar to Alzheimer's, 2, where she's 40% unable to have tongue tip elevation, which teaches speech, 40% hearing loss, so she can't hear all of her students.
But was there any testimony from any expert that would say she can teach right now, but based on her medical history, we consider this to be early onset Alzheimer's, she is going to be unable to continue teaching in 5 years or 10 years, and therefore she is not going, I mean, was there anything in the record that would substantiate a time when she would be unable to a reasonable certainty that she would be unable to perform her duties? Anything.
What Dr. Trigg said is these injuries are significant and permanent. Norris called it permanent and progressive. Nobody gave her a prospect to have any hearing loss return, absent hearing aid, any speech function return, because a lot of it was 3 nerves damaged.
And was it just to put on testimony? I'm sure there's a pay scale out there for the public schools. You're a full-time teacher starting at, you get your certificate and you start full-time teaching. This is what your yearly salary is going to be. Why didn't anybody do that?
And I think that's why we're not here before a remitter, because I think we get that opportunity. And the question was whether there was an inference for this to even get to the jury. Again, that's the albatross that I have, and that's where I looked at the jury straight in the eye and said, this may be 0 on this number. And what we got instead was a round number verdict, and we don't know, how they came up to 2.6 and, why they put numbers in any particular category. But if you take the minimum wage loss, and if you say, all right, Ms. Joynt, there's evidence that you are a threat to these students, And it's hard for me to say, knowing she may hear this. And yeah, your principal vouched for you, but that was before you saw Dr. Driggs. That was before you saw a speech pathologist who said, oh my God, your speech is so bad that you can't do 40% of the sounds. She literally is doing this, using her hands to say some sounds. And we didn't golden rule this jury.
But the evidence belies that. The evidence is that she was an excellent teacher, that the children progressed in her class, despite her principal mentioning that she has to make sounds. I mean,
with ostensibly a one-year track record with a principal that was one of her greatest fans, and Miss Joynt has lots of the greatest fans, and the fear is if Miss Flisherm, if a parent goes back and looks at any of the true, not the glass half full Mrs. Joynt, but the glass half empty Mrs. Joynt, I can honestly say I would love for Miss Joynt to teach, my children, because I know her heart. But speech, maybe not. She's not qualified to be a speech teacher, and that was the inference that was before this jury, and there was evidence of that before this jury with defense counsel's own, defendant's own experts, and I think that's where they made their decision based upon a host of serious issues, particularly with their speech.
With no with no evidence of what she would have earned, what she would fail to earn, and the only evidence being that she increased her salary from zero, from the time of the accident to the time of this trial. I, with all due respect, have a hard time coming up with a $500,000 award with no evidence at all in the record to support that award. And if it's, no doubt she was severely injured. This is a tragic accident. We don't even get into the propriety of driving on a beach, but there's got to be some reasonable basis for the jury to make this decision.
Even if, Your Honor, they had said, all right, Mrs. Joynt, now let's picture in our minds, they're sitting in the jury.
They gave her money for her injuries. They gave her money
Certainly.
for her injuries
Certainly.
and her pain and suffering.
And I would correct counsel, we didn't actually, we waived past medicals, and I think we also waived past earnings before verdict. But even if the jury's sitting in the room, and this is us guessing, and says, all right, maybe because of these serious injuries, she won't be a teacher at 50, 55, 60. And they say, okay, we got to stop then. We can't look at the $500,000 number. That number we got to look at only for remitter. We got to look as to whether they could even make that consideration based upon the significance of her injuries. And, if you're 40% deaf to the point you've got, all of your students lined up this way, and you can't say the word popcorn, and you can't go la 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 la, because you can't get your tongue all the way up to the roof of your mouth. Count how many times your tongue touches the roof of your mouth in your next conversation. It's a substantial amount. And if you can't do all of that, and the jury sees the speech pathologist, the testing with the earmuffs on, and watches Erin, kind of hobble around and sees her for a full week and it makes that assessment. There's enough there to say, all right, at age 50, she's probably not going to be able to, if natural hearing takes effect, she might not be able to have this job. And that's the standard for purposes of today, not whether we prove the full $500,000. I'll submit that the $500,000 comes from $18,000 times a work-life expectancy that she shouldn't be teaching and shouldn't be in this role. Courts have said that we don't have to prove to a mathematical certainty. Your honors are certainly aware. It's our position that this jury told her to retire. and did so based upon, what they heard were her serious and incapacitating injuries. And what they did was give her $18,000, basically minimum wage for the rest of her
That's
career.
not their job to tell her to retire. Their job is to follow the instructions and review the evidence and come to a legal conclusion based on the evidence, not to give her some money and tell her to retire.
Well, and there was no note on the verdict form saying, hey, go retire, wink, wink. It was, it was an assessment of, this is what you're making, this is your career life expectancy, and it,
With no testimony of her career life expectancy. No testimony from any of the doctors that said this is her career life expectancy now that she has this debilitating injury. She can only work for, another 10 years or another 5 years. I mean, there was no testimony as to that. There was testimony as to her injuries, certainly in the nature of them and that they were debilitating, but no testimony beyond that as to she can only, right now, I mean, she's young, but for this accident, she would be working for the next 30 years. But because of this, her work expectancy is only 5 years. And after that, she can't work anymore. I mean, that would be the testimony that you would need so that the jury could make that determination.
That would be, in our mind, the magic word testimony. The difference for the directed verdict standard is, inference. Was there any evidence that she had any damages for not earnings, but work-life expectancy? And the picture painted by Dr. Beck, I urge you to read it and watch that video before you reverse her damages on this, is very, very bleak. And, it's what this jury got to see and got to hear from Ms. Joynt is extremely significant. And they made a determination, and again, the $500,000 isn't the number that we're talking about today. We're talking about whether, there was enough for $1 to even be before them, and we think that there was. Any further questions?
No.
Thank you. Thank you.
Any questions? No? Okay.
Very briefly, the future loss of earning capacity award was pure speculation. This court asked questions and I think understands that even if the jury did tell the plaintiff to retire, there was no evidence that she could not work, as Judge Berger asked those questions. This court should continue to commend the plaintiff, as both parties do, for her candor before the jury, for her likability, for her perseverance, her endurance of a tragic accident. And this court must apply the law and reverse that award of the $500,000 loss of future earning capacity. Perhaps